So this week, the Supreme Court issued its judgment in a case called Guest and Guest, and it concerns a farming family where parents promised to give their son their farm when they died. And in reliance of that promise, the son worked on the farm for many years on really low wages, and the court had to decide on a remedy. Just to make it a little bit more juicy, he wasn't getting all the farm, just some of it. His siblings were going to get some too. I'm Nino Cafaro, I'm a solicitor, and we're going to try and untangle exactly what happened. And cases like this are based on the legal doctrine of proprietary estoppel. And that arises where a person promises another person that they'll be giving an interest in property, and that other person relies on that promise to their detriment. So a bit like the example of the son working on their parents' farm for really naff wages. What happens next? You guessed it. The son falls out with his parents. A ding-dong ensues, and the parents change their wills, removing their son altogether. If that wasn't enough of a kick in the teeth, after all those years of hard toil, they dissolved their farming partnership and boot him out of the house that he was living in. The son wasn't going to take that lying down, of course, so he issued proceedings to prevent his parents going back on their promise. The original trial judge awarded him £1.3 million to satisfy his expectation as to what he would have inherited. Of course, the parents appealed, arguing that the judge was wrong to base his remedy on what their son expected to inherit, and instead argued that the son should have been awarded based on his contribution to the value of the farm or his loss of opportunity to work elsewhere. They also argued that the son wasn't going to get anything until they both died anyway. So by giving him the £1.3 million now, the court effectively accelerated his expectation. Court of Appeal disagreed and dismissed their appeal. So the parents appealed to the Supreme Court. Now, historically, the usual remedy in cases like these would be to enforce the promise, or the court could substitute that with a payment where circumstances made the strict enforcement of the promise unjust. In summing up, one judge rejected the idea that the aim of a remedy in cases like this has ever been based on compensating for the detriment suffered by the person who the promise was made to, and any remedy shouldn't be out of proportion to the detriment suffered, of course. He went on to say that the start point should always be to determine whether going back on the promise is unconscionable, unreasonable at all, and if it is, to enforce it. And the judge said he's getting it early too. Remember, the parents aren't dead yet, so there needs to be a discount for that. Ultimately, it was decided on 3-2, with alternative remedies of either putting the farm into trust for their children, with the parents having a life interest, that means they get to benefit from it whilst they're still alive, or paying a compensation to their son now but at a reduced rate to reflect the fact that he was getting his great expectation somewhat earlier than expected. And he left it to the parents to decide which options to choose. What a conundrum. Now, it wasn't a clear-cut case. The 3-2 decision, plus different opinions from the judges, highlights that the courts are still fairly undecided over how to deal with farming inheritance disputes. It'll be interesting to see what happens in upcoming cases. I'd love to hear what you think. Is it fair on the son? Should the parents be allowed to do what they want with their property? Definitely one for discussion over dinner. For more dinner topics, talk legal with Nino by hitting the subscribe button.